Doug, thank you so much for joining us again. It was quite a day in court. Your motion to recuse Judge Glanville. I'll have to bring it up on the screen here when I can and go through it. But if you want to talk about the substance of it, that would be great. But I was wondering if you could address Georgia state law on when judges consider their own recusal motions, if there's different standards for that or how that works.
Yeah, there's a very clear procedure in the Uniform Superior Court Rules of Georgia of how a judge is supposed to deal with a motion for recusal. So when it's presented to the judge, which is what I tried to explain to the judge today, when it's presented to the judge, he's supposed to take a look at the motion and see if it's timely filed. We have certain time requirements, like you have to file it within 5 days of whatever incident that you learned gave rise to the recusal. It's supposed to be filed 10 days before trial begins, unless you have good reason. In this case, we think we have good reason because we're 18 months into trial and this just happened. But once he determines whether it's timely or not, then he looks at the affidavit. So you have to have an affidavit, and the affidavit has to be very specific, which is why the affidavit, if you look at it that I submitted, has a lot of detail of what we believe happened, or what I believe happened. So if that's sufficient, then the judge has to assume everything in the affidavit is true. And then he has to look and see, assuming everything in the affidavit is true, would that merit recusal? And if it would, he has to refer that out to another judge to look at, to make a determination.
Recusal from the recusal motion, basically. Would it warrant his recusal, or is the standard, would it warrant his recusal from considering his recusal motion?
No, the question is, would it warrant his recusal from the case?
Okay.
Because in Georgia, the judge does not consider their own recusal motion. Basically, and this is going to be the wrong word, but basically, if you make a prima facie case on your pleading, on your motion, that recusal is warranted and it's done in a timely fashion, and I'm oversimplifying it, but then he should refer it out to another, in Fulton, it would be another panel of randomly selected judges to make that call on recusal. Now, I believe the case could proceed, as I read it, while the recusal decision is being made, but that's a little unclear. So I don't think it would have delayed the case. But that's not the procedure the judge decided to use today.
Yeah, and he kind of warned you about what you'd included in the pleading. Said, warned you to tread lightly here. Is there any response to that? Can you respond to that, or?
Well, I mean, when I learned what I learned on Monday, I felt that I had an obligation to my client, and to some degree to the court, to file this motion. I don't think I had an option on that. We haven't seen a transcript of what happened on Monday morning. Perhaps what I learned is wrong, which is why, perhaps my source gave me information incorrectly. But if so, I think that should be up to a panel of judges to look into that and decide.
Yes. And is your I'm not gonna get into the sources, but is the same type of information that Brian Steele presented on Monday? And sorry, it's got a little distracted there. That Brian Steele presented on Monday, and he was careful to say he wants to make sure this is true, right? I mean, you guys are saying on information and belief. Is that the wording in the pleading?
Right, we're in exactly the same boat. I mean, I was very careful that if it was something that I didn't directly have firsthand knowledge of, I stated that it was on information and belief. So to the best of my knowledge from what I learned, what I put in the affidavit is accurate. I mean, it certainly reflects what I learned about what happened Monday morning. If it doesn't accurately reflect what happened Monday morning, and part of me hopes it doesn't, because what is in the affidavit is really troubling.
Yeah, yeah. Especially, I mean, for all defendant, it's troubling, but it seems like there's a lot of stuff in there about Donovan Thomas's murder, which is really why Woody was placed where he was placed in his witness order. Is we're right in the middle of hearing about all that, and your client is actually one of the ones who's charged not only with the RICO conspiracy, which includes Donovan Thomas's murder as a overt act, but he's actually charged with the murder himself. He and Shannon Stillwell, right, who were both on trial.
That's correct. There's several people charged with that murder. Two of the people charged with the murder, including my client, Demonte Kendrick, are in the trial right now. Mr. Kendrick did not commit that murder. And I think that when all the evidence is heard, the jury will come to the conclusion that he's not guilty. But, we're just very troubled by what we learned happened on Monday, especially some of the things that was told to me that the DA's office did. I don't believe in the presence of Judge Glanville, because I don't think he would put up with it. But what the DA's office allegedly said to Kenneth Copeland is really troubling.
Yeah, you said you don't believe in the presence of Judge Glanville. Are you questioning like whether he allowed prosecutors to just talk to Kenneth Copeland alone, or what did you mean by that? Oh, little shaky connection here, but maybe we can get into the. Can you talk about what is the most alarming thing that you heard about that went on in the meeting, other than just the fact that the meeting took place?
Well, yeah, I mean, we can get into the fact that the meeting took place and that we weren't notified of it, and we weren't made aware of it before, during, or after. If it wasn't for this source, we probably wouldn't even know it happened. I guess one of the more troubling things is hearing that in the course of the meeting, I know there's so many troubling things, but hearing during the course of the meeting that Mr. Copeland told the DA's office that he basically, if they insisted on putting him on the stand, he would just get up there and lie. And what we were told is the DA told him, "Yeah, you lie. We're not gonna prosecute you if you lie." And then he said, "Well, I'm going to get on that stand and say that I killed Donovan Thomas," which, I mean, he very may well have killed Donovan Thomas. I'm going to get on there and say that, and the DA's response was, "Well, if you say that, we are going to prosecute you for perjury in that case and false testimony."
For perjury, because and is there
Because they believe he did not kill Donovan Thomas.
Yeah, and that's their whole case. If he really did kill Donovan Thomas, then they'd have to drop the charges, or if they had any knowledge of that. But that's the kind of thing that's an exculpatory statement under Brady versus Maryland, right? Which is what Max Shard raised before court let out today. I mean, those statements are pretty crucial to you, right?
He's raised it multiple times and asked that if there was any additional Brady material that we be provided with that, any Brady material that may have come up in that meeting. And so far, we have not been provided with any Brady material that may have come up in that meeting. So perhaps our source didn't relay accurately what happened, or I don't know what's going on with that Brady material.
What was interesting to me was that, I mean, like has been established, you were not going to find out about this meeting unless Brian Steele had learned about it from somebody who he won't disclose to Judge Glanville. And what I've heard is, ex parte, it was, a lot of people say it was inappropriate to have this meeting in the first place, but to have an ex parte meeting like this and not notify the other side is just totally wrong. But what was alarming to me was Glanville's answer to Max Shard that he's still combing through everything to see what's releasable. So he seems to acknowledge that there could be stuff in this conversation that's releasable, but if he had it his way, you guys still would not even know about this conversation. Is there anything you can say to that, or is there any kind of talk amongst the attorneys about that?
Well, I'm not going to go that far. I don't know that at some point the judge may have notified. I can't get into his head to know that absent our learning of it Monday, he wouldn't have told us about it. But and I don't want to make that guess.
Okay.
But the judge's position on providing us with that transcript has changed over the last 3 days. I believe initially when Max requested that on Monday, it was a flat out no, that the Court of Appeals would get that, and then they could make decisions based on that. And then I believe Tuesday it was some version of that he is considering it, and then you just relayed what the judge told Max today about it.
Yeah, yeah. And for I just went live on TikTok, so people know who they're hearing from. It's Doug Weinstein, who is Yak Gotti's lawyer. He's the one who brought the recusal motion against Judge Glanville today. And we talked a couple nights ago, and you'd said that you were going to be writing something that night. Was that the motion that you started writing that night?
Yeah. I've been working on this along with the whole team at the App law firm, Jay Apt and Katie Hingerty.
Yeah,
We've been working on this for a few days now because we really want. It's very critical in these recusal motions, at least in Georgia, that you dot every I and cross every T. Because there is a very clear procedure that the judge needs to go through that I relayed to you earlier, and it's easy to make a mistake in presenting what you need to present to the judge so that when they go through the procedure, you can get that referral out to another panel that you need.
yeah, yeah. And now you're not obviously involved in the litigation regarding Brian Steele's contempt order. He has his own attorneys, but you're kind of got a front row seat to all of that stuff. And can you talk about what was the feeling that he would actually have to report to jail on Friday? Did you think that was going to happen?
Well, we were all hoping it wasn't going to happen.
Yeah.
Um, and we were hoping that he could get an expedited appeal, and that he could get that supersedis bond that we believed he should get. So
Mhm.
we were I mean, I haven't talked to anybody else since I saw that he got the bond from the Georgia Supreme Court, but we're all very happy that he did get that. And the other thing was, I don't know if you reported on this Monday or not. I don't recall because I feel like these 3 days have taken 3 months. But to watch GACDL, the Georgia Association of Criminal Defense Lawyers, swoop in there and show so much support for everybody was
Okay.
fantastic.
Yeah, yeah. Ashley Merchant really schooled Glanville. I've got that. It's a 20-minute video of her kind of explaining the differences between civil and criminal contempt for him. But I mean, she's so well known for the Trump stuff, but really she was there as president of the Georgia Criminal Defense Lawyers Association. So I noticed that she's the attorney on the Georgia Supreme Court appellate case, but then the Georgia Defense Lawyers Association has actually filed notice as a amicus appellate. So should we expect some kind of brief from them, or do you know about that process? Or
I have not been involved in that. So I don't know.
okay. Well,
Yeah.
what's coming up? Is there any recourse for you with him rejecting your motion? Do you have to wait until there's a judgment here and then you can make that part of your appeal?
Well, uh, if you watch today, I did request the judge to give me a certificate for immediate review. So I was hoping to be able to use that to go to an appellate court to have them review the judge's decision that was made today. And what I was trying to, and maybe I didn't do it artfully enough, I was trying to explain to the judge that I thought it was beneficial not just for the parties, but for the court to have this appellate review that the judge is always referring to, where he says, well, an appeals court will hear that eventually and they'll decide if I'm right or wrong. But I thought it would benefit everyone if we could go ahead and have an appeals court look at that right now. And if the judge is correct and if nothing wrong happened, well, I think that really does improve the situation at the trial. And then if we're right, well, appropriate action will happen. But he did not give me that. So we're looking at what other avenues we have to pursue to see if we can, because we do believe, at least based on what we've heard, that recusal is warranted. Um, Judge Glanville is a very good judge. He has integrity. I'm not quite sure why we're in the situation that we're in today, but I think it would be beneficial if third party, if another set of judges were to take a look at what happened and then make a decision.
Yeah. Is there any thought that there might have been other ex parte meetings going on that you don't know about? Or, I mean, it seems like you found out about this one pretty fast. So is there some thinking that you would have heard about others, or what's the thinking on that?
Secrets are really hard to keep, um, which is why all these conspiracy theories that float around are just so ludicrous. Um, but it makes you wonder if there have been other meetings that we have not been made aware of. You look back at all the late start times, where the prosecutors kind of show up a few minutes before the judge does. But I have absolutely zero basis to think in reality there has been any other ex parte meetings. And what I'm trying to do is not become paranoid at this point.
Yeah, yeah. Oh, regarding Brian Steele's bond, when they say bond, is there going to be a monetary amount here? Is he going to have to go find a bond company and pay 10%, or is that just automatic recognizance, own recognizance?
I don't know the answer to that, so.
Okay.
And I'm sorry, but I am going to have to drop off. I think I
Sure.
mentioned I couldn't stay on that long, but I am glad I got to sit on at this point in time. And yeah, I guess I do just want to close by repeating that I do respect Judge Glanville, and though it can sometimes get heated in there at times, I think we all do our best to remain professional with each other, including the judge.
Yeah,
Okay.
yeah. I mean, I see a lot of recusal motions, and they're not to be taken anything personal against the judge. It's part of litigation, and I think we heard that brought
Yeah.
up in the.
Yeah. But if you're the judge, it's hard to not take it personally. Okay. I
Yeah.
got to go. Thank you very
Thank
much.
you so much for joining us.
Bye.
Thanks. That was great.